What's going on, YouTube? Come back at you with another video. Okay, so I got this paperwork for the 6IX9 indictment. Basically, it's pretty interesting. The government is now trying to protect the snitch in this case, like they do in a lot of different federal type of indictments. So basically, before I get into this though, I got a new channel, Hip Hop Classics Daily News. I'm gonna be doing a lot of videos on there. If you like the content that's on my channel, you like watching my videos, you're wondering why there's not much going on right now on my channel, it's because all my videos for the time being are gonna be uploaded on Hip Hop Classics Daily News. So make sure you subscribe, support all that shit. I'm gonna pin a link to my channel as the top comment. Go check it out, subscribe. I don't have any videos up yet, but a lot of videos coming shortly. So this is the protective order that was just issued with the discovery and this whole 6IX9 indictment. I'm gonna read it to you. Honorable Paul A. Engelmeyer, District Judge, whereas the government intends to produce to Jamel Jones, Roland Martin, Kefano Jordan, Jenzel Butler, Daniel Hernandez, Fuguan Lovick, and Fahim Walter, the defendants in the above captioned matter, certain discovery materials that affects the privacy and confidentiality of individuals would impede, if prematurely disclosed, the government's ongoing investigation of uncharged individuals, would risk prejudicial pretrial publicity if publicly disseminated, and is not authorized to be disclosed to the public or disclosed beyond that which is necessary for the defense of this action. And whereas pursuant to Rule 16D1 and Title 18 United States Code Section 3771, the government desires to protect the confidentiality of the above referenced materials and for good cause shown. It is hereby ordered discovery materials produced by the government to the defendants or their counsel or coordinating discovery attorney that are either designated in whole or in part as confidential by the government in emails or communications to defense counsel, or that include Bates or other label stating confidential, shall be deemed confidential material. Confidential material disclosed to the defendant or to the defendant's attorney or to the coordinating discovery attorney during the course of the proceedings in this action shall be used by the defendant or his counsel or the coordinating discovery attorney only for purpose of this action, shall be kept in sole possession of the defendant's counsel or the defendant or the coordinating discovery attorney, shall not be copied or otherwise recorded by the defendant except at the discretion of defendant's counsel, shall not be disclosed in any form by the defendant or his counsel except as set forth in paragraph 2E below, may be disclosed only by the defendant's counsel and only to the following persons hereinafter designated persons: secretarial, clerical, paralegal, investigative, and student personnel employed full-time or part-time by the defendant's counsel, independent expert witnesses, investigators, or consultants retained by the defendant or on his behalf in connection with this action, potential witnesses, but only insofar as defense counsel may show the confidential information to potential witnesses without these individuals retaining copies of the confidential information, and such other persons as hereafter may be authorized by the court upon a motion by the defendant, shall either be returned to the government following the conclusion of this case, including all proceedings or all appeals, petitions for habeas corpus or other collateral relief proceedings, or the time periods in which such relief can be sought, whichever is longer, together with any and all copies thereof, or destroyed together with any and all copies thereof, with defendant's counsel verifying in writing to the government that such destruction has taken place. Discovery materials produced by the government to the defendants or their counsel that are either designated in whole, in part as sensitive by the government in emails or communications to defense counsel, or that includes Bates or other label stating sensitive, shall be deemed sensitive material. sensitive material disclosed to the defendant or to the defendant's attorney or to the coordinating discovery attorney during the course of proceedings in this action shall be subject to the conditions applicable to confidential material. With the exceptions of paragraph 2B above, sensitive material may be shown to the defendant but may not be maintained in the defendant's possession. The defendant and his counsel shall provide a copy of this order to designated persons to whom confidential material is disclosed pursuant to paragraph 2E. Designated persons shall be subject to the terms of this order. The provisions of this order shall not be construed as preventing the disclosure of any information in any motion, hearing, trial, or sentencing proceeding held in this action, or to any judge or magistrate of this court for the purposes of this action. This order may be signed in counterparts and transmitted by facsimile and or electronic copy, each of which counterparts will be deemed to be an original and which taken together will constitute the order. So basically, this order is protecting the confidential informant in this case, number one. So these defendants are not going to have access to this information that the feds have. There's going to be no more information released as far as this case is concerned. There's probably not going to be that many more updates until trial. The people in this case, as far as defendants, they're not going to have very much access to this information as far as confidential informants and things like that go, aside from being able to see it with their attorneys. They're not allowed legally to speak on it. The attorneys aren't allowed legally to speak on it. And basically, this is all done, again, to seal the identity of this confidential informant. And even more than just that, I think the most important part of this that people understand, especially anybody that could potentially be connected to this situation, this investigation into 9Trey is not over. They're still investigating. They're still looking to bring people into this indictment, and anybody who has any connection to this case or anybody who is connected to any of these defendants in this case, I would definitely advise you to be very cautious of how you're moving. Do not do anything illegal. The feds are still watching. They've been watching, and they've been paying attention to who is associated. They know exactly what's going on out there, and they're not done investigating. So that's just a warning to anybody out there potentially who could still be involved. Just understand that because these people were indicted, it doesn't mean that this situation is over. This is a superseding indictment. More people can be added. And it specifically says that one of the reasons they're doing this is because if prematurely disclosed, the government's ongoing investigation of uncharged individuals, it could impede that. So basically, there's more people they're looking at who are not charged at this point. And if this information gets out there, it could compromise their investigation. So just be aware of what's going on. Anybody involved, I don't want to see anybody going to prison over this shit. So move smart. Let me know what you guys think in the comments. I definitely appreciate you watching. Again, if you like the videos, you like my channel, make sure you subscribe to the new channel because that's where the majority of my videos are going to be going. I definitely appreciate you. Hit the like, leave some feedback. Peace.